Forms will be sent via email after the program. With that, over to you, Andy.
Thank you, Taja. Good morning. I hope this webinar finds everyone well and that you and your families are staying safe. Welcome. It's our honor to bring to you this program entitled Open Court, Return of In-Person Jury Trials in Philadelphia and Resolving Cases During the COVID-19. My name is Andrew Susko, and I'm the managing partner of White & Williams. Thank you all for attending this program today. We'll be pushing through things with the objective of completing the program within roughly an hour's time. We might run a little bit beyond that, and all presenters will be available for an additional half hour if there are questions. And just so you know, as Taja mentioned, if you want to ask a question during the program, use your chat feature. You can use your mouse and or touchpad to activate your cursor, and at the bottom of the screen should appear a chat bubble, and then you can navigate that to ask your question. We'll do our best to answer your questions in real time to the extent possible. Otherwise, we'll hold questions till the end to respond to them. We have a highly respected and distinguished panel today. You have their biographies sent to you, along with materials sent by our first and featured speaker, Judge Daniel J. Anders. Judge Anders next year will reach 15 years of service on the bench with the Court of Common Pleas, the trial level court in Philadelphia County. He is currently the supervising judge of the civil division. In that role, he manages roughly 30 judges on the civil side of the House. And we're delighted that he can participate in this webinar today. Previously, Judge Anders was an attorney at Pepper Hamilton, now Pepper Troutman, practicing in the field of commercial business litigation. He's a University of Pittsburgh Law School graduate. In a very short time, Judge Anders has really accomplished much in this position as supervising judge in the civil division. He talks in terms of a partnership with the private bar to fairly move cases through the courts of common pleas, the trial level court, to resolution. And he and his team have done what many said really could not be done, and that is reopened our Philadelphia County courts for in-person jury trials. And on a personal note, I want to thank Judge Anders in advance for his leadership, innovation, transparency, and most importantly today, for being willing to take time to share with you the reopening of our courts in Philadelphia County. Judge Anders.
Good morning, everyone, and thank you for attending. Thank you, Andy, for hosting this webinar and bringing together a distinguished panel. I very much appreciate that we have a lot of important decision makers from the insurance industry and companies within Philadelphia, or at least who face lawsuits in Philadelphia, as well as distinguished members of the bar. I honestly can't remember the last time that this sort of a group of people got together to discuss these issues, also in partnership with not only the PADC, but also the Philadelphia Trial Lawyers Association. Why don't I go through the slides, and because I think what I have to say will generate more than a few questions. And if Ryan, you can go to the next slide. I thought it was important to give some perspective of what we're doing, as well as what the rest of the neighboring counties are doing. You all know that we suspended trials a year ago, March 17th, and under the direction of Administrative Judge Lizette Sheridan Harris, we restarted March 4th. The other counties, and every county faces unique challenges in terms of their jury convening space, their trial courtrooms. And so I just wanted to, I'm not trying to disparage any other county that's not where we are. As I said, everybody has different and unique challenges, but I do think it's helpful at least to understand that we are really leading, one of the leading jurisdictions in terms of returning safely to in-person jury trials. And for the most part, our neighboring counties are suspended until really early summer. If you go to the next slide. In January of this year, we started to hold pretrial conferences to schedule cases for trial in 2021. And to date, we've scheduled over 400 civil jury trials for in-person jury trials in 2021. And we wanted the mix of cases to be roughly the same as it was before the pandemic started. So we have 160 major jury trials that are date certain. Mostly those are the complex cases, your med mals, your product liability, nursing home, your FELA type cases. We have 70 major jury pool cases, which are both expedited and standard track cases, 150 ARB appeals, and then 2 mass tort cases, asbestos and Risperdal. What I did not list is we actually have 1 Commerce Court case that's going to trial. I believe it's listed in June. And to break that down, in March 4th, which is when we start our first jury, we scheduled 40 jury trials for March, of which 11 were major jury. Of those 40 jury trials, 12 juries were selected, which resulted in 3 settlements, 5 defense verdicts, and 4 plaintiff verdicts. All other cases were settled, with the exception of 3 cases that we continued. In April, we roughly stayed the same in terms of the number of jury trials that we called to trial. You can see the stats there. 11 juries were selected, 3 defense verdicts, 3 plaintiffs, and 5 are, well, that number was as of Tuesday. 5 are ongoing. Those are probably all now resolved. And in March, we were picking 2 juries on Thursday and 2 on Friday, so a total of 4 a week. In April, and so for long as we're required to remain socially distant, we will pick 3 juries on a Thursday and 3 on a Friday for a total of 6 panels each week. In May has 5 trial weeks for us, so we bumped up the number of jury trials that we have called. We have 68 jury trials that have been scheduled, of which 18 are major jury, including 7 medical malpractice trials. If you can go forward to the next slide. What of those nearly 400 cases, what were the cases that we picked and why did we pick them? So our first priority was to, when we were restarting jury trials, is we wanted to reschedule all the cases in 2020 that had actual trial dates, either as a trial date certain or trial pool month. And the breakup of that was 149 complex cases, including 72 med mals, 64 standard and expedite cases, and 150 arbitration appeals. All of those cases have in fact been scheduled into 2021, with the exception of about 10 cases, 5 which were simply too large to fit into any of our courtrooms, and then 5 where the parties all agreed, we don't want to go to trial in 2021. We're happy to wait until 2022. To give an example of the complexity of some of the cases that we're calling to trial, we have a 5-week-long products liability trial in July that has 8 counsel tables. Now, all the counsel tables, as you'll see, are in the well of the court. Each table holds 2 people, and each person is 6 feet away at counsel table. There's no one in the gallery other than the jury. So that's 16 people, whether it's clients, lawyers, legal staff, adjusters, experts. It's anyone who needs to be in the courtroom is seated now at counsel tables. The next priority for us to schedule cases are the cases that had pretrial conferences scheduled or projected to be scheduled in 2020. That number, as of earlier this month, was 782 cases. breaking them down into 153 complex, 241 standard track, and 388 expedited cases. For the most part, we believe we're going to call most of the standard track, most of the expedited. The complex cases are on hold until we see how the other 149 complex cases that are currently scheduled for trial, to see how those cases dispose. If they dispose, as we hope that they will, that a significant number of them will settle before trial, before picking a jury, then we will be able to schedule more of those cases into 2021. If, however, they require a jury to dispose, then it is not as likely that any of those cases will be scheduled for trial. Next slide. Now, how's the pandemic impacted the court and the practice of law? So during the pandemic, we relaxed our case management protocols in recognition that, in fact, both the business of the court and the practice of law were upended. Jury trials were suspended, which removed the primary driver of settlements. Discovery motions were decided on the papers instead of in discovery court, which resulted in weeks or months of delay before being decided by judges. Case management deadlines were routinely extended by team leaders or by precipice, based upon the parties' agreement, which resulted in a culture of continuances being routinely granted. Lawyers did not return to offices for months, so that may have prevented them from accessing their paper files, and you also had to learn how to litigate virtually. And of course, clients and experts such as frontline medical professionals were pressed into service and unavailable for typical litigation needs. Next slide. Now, given the fact that we've taken a couple of steps to get ourselves back on track, what can we expect for cases that are not scheduled for trial while we're still litigating in the middle of a pandemic? Now, the number one priority for us as a court is to tighten up our case management protocols with the goal of keeping our current inventory current. And what that means is that for cases filed in 2021, we are going to manage those cases to disposition as we did pre-pandemic. We are able to do so because we now have our virtual discovery court up and running, which means that discovery motions are resolved within 3 weeks. So you get in front of a judge 3 weeks from when you file the motion, instead of potentially waiting 3 months. All case management orders have been timely issued for cases filed after January 1, 2021, which is 90 days after the case has been filed. Motions for extraordinary relief will be routinely denied unless there's truly an extraordinary reason to grant them. And of course, we have jury trials with firm trial dates, with the goal of having a jury panel, an appropriately sized courtroom, and a trial judge available. We very much want to go back to where we were pre-pandemic, and these 4 different options or components are going to allow us to get back there. We will not be able to meaningfully increase the pending inventory so long as we're required to remain socially distant. And what I mean by that is, in the materials that I sent out to you, if you look at a rolling 3-year average, 2017 to 2019, those 3 years, there was an average of 302 jury trials to verdict in Philadelphia. That's mass torts, major jury, arb appeal, and commerce court. If we're picking 6 juries a week, which we are, times 52 weeks a year, that's 312 juries in a year. So in a perfect world, if we're only picking juries that are required to go to a jury verdict, we will not accumulate any additional inventory starting in April. We will clear all the cases that we would normally clear pre-pandemic. And so that's what I mean in terms of why we expect to manage those cases in 2021 and keep that current inventory current. If we go next slide.
Judge, you mentioned a continuance, 3 continuance cases in March. We did get a question from the audience about whether, when both sides agreed, maybe the case won't be scheduled, but what if one side, either parties or lawyers, fear getting back into the room and the courtroom and the safety aspect of that, and don't want to proceed, but the other side wants to proceed? How's the court handling that?
Yeah, so I've sat through a few different pre-trial conferences. I actually held 20 myself on Monday on these expedited cases. That issue did not come up for me. It did come up in January, and I know that the judges that were, the team leaders that were handling those conferences, they moved those cases into 2022. Now, when you're moved into that pool of 2022, you will not be a priority for us when we restart looking at those cases, because we've offered you the opportunity of coming in to 2021. But we are not going to force or require anyone who has a legitimately held belief that they are at some undue risk for coming into the courthouse. So let's look at case management options. And I'm not endorsing any particular option. I'm just putting out there what are some options to address what I call increased pending inventory, or other people call it backlog. And we certainly have a backlog of cases. The first option is we could recreate the day forward, day backward program, which was successfully used in the 90s to reduce a substantial backlog. That ensures that the current inventory remains current while simultaneously attacking the aged inventory as judicial resources allow. So for example, a case filed this month, which is expedited, we will manage that case to a disposition in May 2022, 13 months, that's the normal track. The standard track, we would manage that to the standard normal track of 19 months, and complex cases would be 25 months. That's the first option. The second option is really to do what we're doing now. We call cases to trial based upon their age. We mechanically call cases based upon the oldest cases, those that have been waiting the longest to go to trial. And that's what we're currently doing in terms of how we are calling cases for 2021. Newly filed cases, such as those filed this month, will be delayed for whatever time it takes to clear those older cases. We're not delayed by more than a year. I don't really want to put a number on it, but it's certainly, we're not delayed more than a year. But we're certainly delayed more than 6 months in terms of the actual delay. And then the last type is a combination of the two, where you focus on one type of case with the oldest pending inventory. In this case, it would be our major jury cases, while we intentionally do not call other cases and put those inventories on hold. You could, for example, decide arbitration appeals. They've already had one neutral evaluation of their case at the arbitration level. And so we can intentionally pause those trials for 6 months maybe, and focus exclusively on doing major jury cases. Again, if you look at the data that I sent to you, almost half of our jury verdicts in a year are from arbitration appeals. If we pause those cases, then we can essentially double the number of cases that we will evaluate or send to trial on the major jury track. Next slide. What limits our ability to schedule trials during the pandemic? The real limit is the availability of jury panels. It used to be the availability of judges. We could bring 400 people in, we could pick 10 juries, try them all on Monday, and several of them would settle over the weekend. But the limit was the ability to have judges available to try them. I was on Judge Rau's team. I can't tell you how well she was as a team leader. She was awesome. And as soon as I settled a case, or a case settled, the next day I was on trial with another case. And so that was the limit of her ability to schedule cases, was my time. The limit now is how many jury panels do we have available? We have 6 a week. And our promise to you, if we give you a trial date in 2021, we have a jury panel available, we have 2 courtrooms to try it in, and we have a judge to hear it. The most important of that is a jury panel. Now, if you have a 5-week-long case, that case in July, that settles during the first week of trial, how many other cases can I call as a result of that one 5-week-long case being settled? Pre-pandemic, we could have called the trial at least another 10 cases, that some of them would have taken 2 or 3 days to try over those couple of weeks. A lot of them would have settled. During the pandemic, under the structure we have now, if that case settles during the first week, I have an empty courtroom for 4 weeks, and I have a judge available for 4 weeks. I do not have any more jury panels. I cannot dispose of any more cases because that case is settled. If it settles before the trial date, then I can call more cases to try. It won't, I can guarantee you, it won't be a med mal case. It won't be a products liability case because you can't try those cases so quickly. But I can put an ARB appeal. I can put a rear ender car accident case. I can call those on 24 hours notice and get those cases to trial. Next slide. So what are the protocols for the in-person jury trials during the pandemic? Number one priority, wearing a face mask at all times in City Hall, unless you're in a private office like I am now. That applies when the witness is testifying, when attorneys are examining the witnesses. It applies to all trial participants, including the trial judge. It applies even if you've been vaccinated and fully vaccinated. Maintaining 6 feet social distance when you're inside City Hall. You'll see in a minute that the gallery is now the jury box and the witness is seated in the jury box. All the chairs in the well of the court, which is where the lawyers, client, adjusters, experts, anyone who needs to be in the courtroom will be 6 feet apart. And for the most part, we have 4 counsel table courtrooms. There are 2 courtrooms that have 8 counsel tables, meaning we can fit 16 people within the well of the court. We have strict enforcement of those courtroom capacity levels. So at the pretrial conference, you will be asked, how many people do you need to have in trial, in the courtroom during the trial? And once you agree to that, we will hold you to that. Because if you show up in a courtroom with 8 people and you've only told us 4 are coming, we don't have the ability to move you to another courtroom, and we can't create more seats in the courtroom. So 4 of those people are going to have to watch the trial via YouTube. We have enhanced ventilation, enhanced cleaning, and we also conduct COVID screening questions of every day of all of the courtroom participants. In terms of the court doing that, we do that for the jurors, we do that for the courtroom staff. It is on the lawyers to do it for anyone that the lawyers are bringing into court. Next slide. This is my old courtroom. It's courtroom 285. It's a beautiful courtroom. If you've never been in Philadelphia, it's truly a historic building. That is what it looked like before the pandemic. The gallery probably has 50 seats in it. The jury box has 14, and you see 2 counsel tables in the front. Next slide. That's what it looks like today. There are 14 jurors that are seated in the gallery, all 6 feet apart. In the jury box, there's only 2 chairs, and in front, in the well of the court, spread out are several tables and chairs. Let's go back and we'll show the before and after. So back 1 slide, and then forward.
Judge,
All right,
can you comment on, since everyone's masked, as I understand it, both witnesses and attorneys, about efforts made with regard to the sound system in the courtroom and how that works?
Yes. So proper mask wearing is covering the nose and the mouth. It must be tightly fitted, and it also must be CDC compliant. There are clear masks that are, one of them is made by Leaf. If you Google Leaf mask, they have CDC compliant face masks that are clear. A face shield is not a face mask. So a face shield is not a substitute for a face mask. With the permission of the trial judge, the witness may pull down their mask before they start testifying, just so that they can briefly show their face, but otherwise they are masked the entire time. In terms of the audio quality, we actually just this week removed all of the lapel mics because we found that lawyers were having a difficult time putting them close enough so that the sound was effective. We now have what some people refer to as Britney Spears microphones. So it's a headset that the microphone goes right in front of the mouth. It's like wearing I guess a retainer, perhaps. It's not very comfortable, but the sound certainly is very good. And so no one shares a mic. We have enough microphones in the room for every lawyer that's in there. Let's go to the next slide. So that's looking from the bench out to the gallery. Again, in the well of the court, that is a 6 counsel table format. So there's 12 chairs in the well of the court. The podium on the right is where you can conduct openings and closings with the permission of the presiding judge. Otherwise, you're going to remain in your seat where that location is for the rest of the trial. Next slide. Again, a different view. Now we're looking from the gallery back to the bench. Those green boxes, you can move those chairs in any direction that you wish. And we understand that part of the time your back may be facing to the judge. That's perfectly fine. It may be a side view, but you have to remain within that green square for basically the duration of the trial. Next slide. And I will tell you that there have been quite a few reports and surveys of jurors that indicate that if a lawyer is wandering around the well of the court, not wandering around, but you know, in the well of the court, and they are even if they're staying within or outside the 6 feet, that the jurors get nervous, right? They don't like to see lawyers moving around because they don't know where the 6 feet is. With these, they do know where the 6 feet is. They know exactly where the line is, and they know that people can apply with it. This is a jury deliberation room. So every trial requires 2 courtrooms. That is in a campfire circle format, so everyone can see each other during deliberations. The table in the middle is for exhibits. There's a bottle of hand sanitizer there, so if someone needs to actually touch the exhibit, they hand sanitize themselves, they touch the exhibit, and then they go back. Next slide. So what to expect during the trial? As I said, opening statements and closing arguments can be made at the podium with permission of the trial judge. You'll remain seated for the entire trial. Sidebars will be rarely granted, and if they are, and I do understand there are legitimate reasons to have sidebars, maybe you want to make sure you're complying with the court's ruling on a motion in limine, we will send the jury out. That's the only way to do it. The other way to do it is to have everyone getting on to a texting app, including the judge, and you do the argument via text. Our Wi-Fi isn't that good, so, and probably our judges, for the most part, aren't that tech savvy. All breaks and lunch recesses are taken outside of City Hall, and witnesses should arrive 15 minutes before testifying. We actually have a chair set up just outside the courtroom so that there's not a delay in calling witnesses. Next slide, please. So the feedback from in-person jury trials, first of all, the jurors are very appreciative that our courts are reopened. They understand how important these cases are to you and to the clients and to the legal industry in general. They look forward to doing their service, and they also appreciate all of the communication that we do with them in terms of our efforts to make sure that there's no transmissions and everyone's safe. Counsel have provided feedback, including that they have found that jurors have been diverse in terms of age, sex, and race, that they are willing to participate even during the pandemic. And for the most part, we are giving people panels of 38 to 40 jurors, and they are exercising their strikes generally somewhere in the 20s. It could be, I don't think many juries out of those 20 or so that we've done so far have gone even into the 30th juror before they had exercised their strikes, because they have people who want to be there, right? No one's trying to get out of jury duty service if they're showing up during a pandemic. The mechanics of jury selection, we've made no change to the summons procedure. So we're calling the same people we would last time, pre-pandemic. The only thing that we've done is that if someone calls and they call our jury staff and they say, is this a joke? I got this jury summons. Are you really doing jury trials during the middle of the pandemic? We say, we'll see you in 6 months. It's almost like a no excuse voting to do mail-in voting. You really don't need to give us a reason. If you're not comfortable coming in, we will postpone you for 6 months. Jurors do answer COVID screening questions before reporting to jury duty. And if in fact they answer any of those questions, yes, we do not have them come in. And we certainly have had to summon more jurors, but we've never had a day where we didn't have enough jurors show up. I'll give you one example. In January, I think it was January 15th, the state Supreme Court convened a grand jury for grand jury selection in Philadelphia. This is after the insurrection in the Capitol, before Biden is sworn in, at the height of the pandemic. They wanted 300 jurors to appear. They got 450 jurors to appear. They had to turn people away because they had so many people who wanted to serve on a jury. Next slide. So the resumption of our jury trials has increased the settlement rate for major jury cases. We actually have a pretty good visibility into our cases in terms of when they settle, how they settle. And pre-pandemic, we looked at the 1 year before. They were settling at 397 per month. That's major jury cases only. During the pandemic, that's from April 1st to February 28th, 2021, they were settling at 237, so not quite half of what they were pre-pandemic. In January and February, those 2 months alone, they averaged 327 major jury cases. And in March, we went up to 375. All of that increased activities because we were first planning jury trials, then having pretrial conferences in March. We actually then started to hold jury trials. A really interesting statistic is, remember, there's all these cases with pretrial conferences in 2020. They're still stuck there. That's how we determine the priorities, that we're not moving them, those dates forward. We're just keeping them there as placeholders. February 3rd, we had 923 major jury cases with pretrial conferences. 2 months later, we had 782 left. 141 or 15% of those cases settled without us doing anything for those cases except calling jury trials in other cases. So we did not list them for pretrial conferences. We did not call them for trial. We did not call them for settlement conferences. We did nothing with those cases. And in 2 months, 15% of them settled. If you break it down further, 17 of the 170 complex cases, those are med mals, product liabilities, 10% of those settled. And astonishingly, you look at the expedited cases, we had 495 February 3rd. 2 months later, we were down to 388. That's 107 cases that settled without us doing anything to those cases other than try cases in other, do jury trials in other cases. Next slide, please. We are devoting a lot of judicial resources to facilitate settlements. We have half-day mandatory settlement conferences with the trial judge. It may not be the assigned trial judge, but these are experienced trial judges that are going to spend 3 hours with you to try and get this case to settle if it can. I understand that there are no pay cases. And if you've spent time with a private mediator, with someone like Judge Rau, and she can't get that case to settle, we will not spend 3 hours with you. You know, it will probably be a 10-minute conversation. And, you know, because we understand you've made a good faith effort to try and settle it. That being said, if we can settle those cases, we will do our level best to do so. Half of the cases that have gone through that settlement conference have in fact settled at the conference or shortly thereafter. The conference is held 30 days before the actual trial date. So it's sort of a sweet spot in terms of things getting ready to go to trial. And it also requires the parties to meet and confer before the settlement conference to exchange a good faith offer and demand. I've been in weekly conversations and contact with the MCARE administrator, Beth Person. She receives the docket information for every medical malpractice case in Philadelphia that's either listed for trial or a mandatory settlement conference. Her team are actively participating in the settlement conferences. They are prepared. This is a great partnership between the two of us. And again, if that case can settle, and you know, if you looked at it, there are 420 new medical malpractice cases that are filed every year. And the 2017 to 2019 3-year average, 20 of those went to trial. And so it's a very, very small number of cases that actually have to go to trial. Of the 72 med mal cases that are scheduled throughout 2021, 52 of those on an average, should settle before trial. And that's our hope, is that those cases do fall out. Of course, if they do go to trial, the statistics show that it's more likely than not to be a defense verdict. And so our courts are open. We're trial courts, right? We are open for trials. That's what we do. And so we are ready for you to try your case. If you believe it's a no-pay case, or you believe you have some significant disagreement about the value of the case, we are here to try that case and provide you the forum to resolve the dispute by the way of a jury verdict. But again, if that case can settle, then the important thing is to settle before you pick a jury, and not the day before, but a couple of days before. Even a couple of days before will allow me to call other cases to trial and to reduce our backlog. The other part, if it's not a complex case, we are holding mandatory settlement conferences on the other cases, the ARB appeals, the the expedited, and standard track. One more slide, I think, is what I have left, or is that it? Yeah, we monitor almost daily the COVID-19 data. As of April 19th, the health department reported that they had over 1.1 million doses administered in the city, resulting in 451,000 people fully vaccinated, 680,000 people receiving at least one shot. They have a goal of reaching 160,000 vaccinations per week. They are not reliant on the J&J vaccine. That only forms 2% of the vaccinations that they've done so far. This is truly a race between the variant and the vaccines. The UK variant is right now about 26% of new infections. It is 50% more contagious than the original coronavirus that came from China. On March 2nd, which is when we started jury trials, we were at 9.8 new infections per 100,000. It peaked last week at 42. We were at 38 on April 20th. It is leveling out in the high 30s to low 40s right now. And so we're looking at that. And notwithstanding the fact that it has increased 4 times, we still believe that we can safely operate it. We're doing that in consultation with public health, risk management, and just looking at the CDC recommendations. And so our key to making sure that we can safely conduct jury trials is strictly adhering to those preventative measures: masking, social distance, hands cleaning, and ventilation. And we cannot let our guard down just because people are vaccinated. We really make sure that everyone's abiding by everything. I think that's the last slide. Am I right? Okay, great.
Thank you, Judge Anders. There was one chat question for you. Perhaps you can look at it. I'm going to turn it over to Taja for the CLE code and then introduce Judge Rau.
Yeah, so bench trials, the bench trials, we do not have a backlog in bench trials. We have conducted more than 400 bench trials since September 2020, which is when we restarted bench trials. All of our bench trials are virtual. They're done on Zoom. I've had zero pushback from anyone saying that they can't do a jury trial, a non-jury trial on Zoom. The only cases that are not proceeding by way of a non-jury are the cases that are on hold per the CDC moratorium on either evictions or other property related cases, the mortgage foreclosure cases. But if you have an equitable case that you're not entitled to a jury, all those cases are going forward. We do not have a backlog. In addition to the cases that you see that are going to trial by jury, we are trying somewhere between 65 and 85 non-jury trials every month. Some months are a little heavier than others, but in addition to doing jury trials, we're doing non-jury trials. Our judges are doing non-jury trials, case management conferences, and settlement conferences.
Thank you. Taja?
Well, let me, one more question I'll answer. So Dan, Jack, and Dan Furhat and I have met several times. It's the 3 Dans, it's the triple threat. We rarely disagree, but we have disagreed on whether a witness may appear remotely. In-person jury trials means in person. And so we are requiring all witnesses appear in person, that no one has the ability to remove, to zoom in. And so that may mean that you have to take a trial dep if someone is otherwise unavailable. Okay, thank you.
Thank you, Judge Anders. At this time, I will be launching a poll for CLE-CE. Please select the answer in the box as it appears on your screen. There is no right or wrong answer. This is purely for attendance. If for some reason you cannot answer the question, please send your response via the chat box. If you have joined via your phone, please send your response via email to events@whiteandwilliams.com. The first poll question is, what is today's date? I'll just give you a second to respond to that. Thank you so much. On to you, Andy. Thank you.
Thank you, Taja.
You're muted. You're muted, Andy.
Thanks. Thank you. Our next presenter is Judge Lisa Rau. She also served as a Common Pleas Court trial judge at the Philadelphia County Court of Common Pleas, and served as a team leader for 5 years. 4 months before the lockdown was announced, she retired and opened Resonate Mediation and Arbitration, LLC. So we'll be very interested, Judge, in you being right at the forefront of operating a new mediation arbitration service and then seeing the courts locked down. I would just say that Judge Rau, as Judge Anders alluded to earlier, developed a reputation of being fair, a fair judge, no nonsense, who developed an incredible reputation of being able to resolve the most complex, the most difficult cases, and do so with the right touch between the parties to get them resolved. The Stanford law grad who lectures at UPenn, Temple, and Villanova. We're very happy to have Judge Rau to give her perspective on private ADR mediation trials, summary trials, and the like. Judge Rau.
Thanks, Andy. I'm going to cut back my time to 10 minutes, and I've actually set a timer so that, because I really know that everybody wants to hear Anna, Dan, and Dan as well. So if you hear a little jingle, you'll know I'm getting politely cut off. So if masked, socially distanced trials with unpredictable juries in 3 different courtrooms gives you a little bit of the jitters, try online mediation first, because because it's voluntary, you can always go back and try the courtroom and have a historic socially distanced trial. But if you really want to make sure that that's your last alternative, take the decision makers and try an online trial. As Andy alluded to, my timing in leaving the bench actually in some ways was fortuitous, because I wouldn't have been able to function much as a judge during the last year. And I do want to commend the court and Judge Anders in their Herculean efforts to get the court moving again. I really do think with the case management system they have in place that we really are only looking about a year of delays. And with the great Judge Pro Tem program going, I think we'll catch up. But what I'm going to focus my comments on today is how online mediation, much to all of our surprise, is effective. and how it's effective and why it's effective. So I'll be comparing my experience with online mediations, both on the bench when towards the end of the time there, I was doing 8-hour and 4-hour mediation. So traditional, kind of what you think of as private mediation, longer mediations, and then what I was doing right before the shutdown, and talk about some of the ways that online mediations are effective, and in some ways, some of the benefits that we discovered. When things shut down, I have to say that I kind of went, okay, this will be 6 weeks, 8 weeks. I'm not going to force anyone to do anything online. I sent out an email to all the mediation scheduled, and people said, oh no, we want to move forward. And again, most of them had trial date certains already listed, and we all thought this was a temporary period. So it was dive in, total immersion, figure this out. I think one of the things that made online mediations effective at the beginning was we all recognized that we were all beginners, and we were kind of helping each other through. I kind of like to break it down into phase 1 and phase 2. The first phase was really when we were kind of tiptoeing in and saying, will this really work? How can we make it work? And then when we realized that the resolution rate was as good, if not slightly better than it was in in-person mediations, we started to see that in phase 2, there were some considerable advantages. One of the things that I think is critical for any mediation, in person or online, is to have a pre-mediation conference. But when you're doing online mediation, that's really critical. It gives you an ability to really focus in on the tech checks to make sure that not only counsel are prepared, but counsel prepare their clients. And I don't want to waste our time today talking about tips for being effective. I have provided a 3-page sheet in the materials that you've been given that kind of walks through a lot of the mistakes people make in preparing for online mediations. But in the pre-mediation conference, that's where you really flesh out with counsel how people are going to participate and make sure that they have the proper tech. Now let me move to phase 2. When we figured out that they work and they can be effective, we started to realize that there were some things you could actually do in an online mediation that we had not been doing in in-person mediations. One of the most exciting things that we've discovered is that you can increase the number of people who are participating. This is particularly effective in the catastrophic injury cases where frequently on the defense side, there have been a whole committee of people who have conferenced a case and have strong feelings about the case. With an online mediation, you can actually have those decision makers observe the joint session or get involved at some level, talk with the mediator, and not be stuck with being there for an 8-day session. I mean, these are people who are frequently very busy, have a lot of things on their plate, but we've been able to invite vice presidents in a company that needs to help decide something, higher level claims representatives, and things like that. And they really appreciate it because we can involve them at a set time for the joint session. And then they've seen it. And the lawyers are in a better position too, because they're not having to kind of translate what happened and how the plaintiff comes across. A second thing that has been really effective and fun is that we all know that sometimes claims representatives who have to travel frequently they're jumping on a train or a plane at 3:30 or 4 in the afternoon, right as you're getting to the critical point of needing their decision making, and we lose them to travel. For every online mediation I've had since the outset, we've not only had claims representatives present, but they don't do the I'm on the phone. They actually are physically present on the video, and it makes such a huge difference. The third thing that we've seen is that plaintiffs can actually participate in a way that's sometimes more comfortable for them. We've had a number of plaintiffs who either had a birth injury, were bedridden, had underlying conditions, things like that, and they were able to participate from home. And what we noticed was that people are actually a little more comfortable when they're in their home environment. And so they were better decision makers, because there's that whole aspect of when you're in a foreign environment, when you're around a whole bunch of people with suits in a conference room that doesn't feel familiar, it's harder to relax and have your brain work well, frankly. And so people seem to be at a higher comfort level during the online mediations. The one thing I've actually been noticing as lawyers have been getting back in, dragging their clients into the conference room and putting masks on them so that they can be near them. That's actually worse. So I would encourage people to at least make sure that their clients can participate without a mask and in a comfortable environment. The other thing that's also been different is there's a broader range of ways to communicate, because with the online format, you can create, I mean, you have unlimited real estate. You can create 10 different breakout rooms. So it's really easy for the lawyers to say, you know what, I really want to talk to you without my client in the room. And they don't have to do it in a way that might make their client offended or suspicious or something like that. They can just simply send a text to the mediator saying, can I talk to you privately, and we can move them to a joint room. Or they can just mute their screen and call the mediator on the phone. So there's kind of, and recently we had a large party case where we could put all the defense lawyers in one room where we could talk about the challenges of going against this plaintiff alone without the plaintiff even knowing that was taking place, which if we had been in person, the plaintiff would have seen all the defense lawyers going into a room. So there's that level. There's also the ability to watch somebody on a screen without staring. So you can actually really judge their demeanor, their reaction to what you're saying. And you're not, like in their face staring at them, but you can really judge in a way that sometimes you'd be afraid to, out of politeness, be up too close or staring at someone too much. What I've also noticed is when you tell counsel, I want a 5-minute opening presentation, sometimes in person that became an hour. and you were kind of stuck. That's just not happening online. I think people just really get it that online it's much more efficient and focused. The other, and my time is up. So one, just to follow up really by clicking off the final things that have been really fun with online mediation is it's actually much more comfortable during the breakout sessions because you can kind of be in your own space, get your own coffee, do other work. You're not captured. And finally, the ability to share documents and do case analysis by sharing a document on the screen, or to draft up a settlement agreement on the screen, is actually just easier. in the online format. So I think we'll end up keeping a lot of these features. For example, having a hybrid thing where you can have higher level decision makers join in and that kind of thing. I think what we've really learned with the online mediations is that people's talent really does translate online. You really can do the same kinds of things, and in some ways you can do them better, faster, and it's easier to schedule. So if you are feeling a little queasy about in-person trials, just try an online mediation first, and make sure that the in-person trial is just a last resort. So if you have a lot more questions that I didn't get a chance to answer today, I'm going to just put my email in the chat screen so that you can send me that question or give me a call. But I want to make sure that Anna and Dan have an opportunity to talk.
Great. Thanks, Judge Rau. Appreciate it. Very informative and interesting. We're going to turn it over to Anna Watson. She's a member of Clark Hill International Law Firm. Her resident office is in Chicago, and Anna's practice area is focused on insurance and reinsurance, and both foreign and domestic, and providing advice, counsel in both pre-underwriting claims reviews and then also risk assessment for clients with a specialty in the healthcare area. Anna is no stranger to Philadelphia County. I've gotten to know her in some mock trial settings. She's incredibly insightful, can cut to the heart of a matter and value both liability and damages quicker than anybody I know. And so I'm going to turn it over to Anna for her comments from an insurance industry perspective. Anna? You're going to need to unmute.
Yeah, I was saying, I don't know if that's good or bad, what you just said. So anyways, first of all, I would like to thank Judge Anders and Judge Rau again for taking the time to give us some clarity on, what we're trying to do with respect to litigation now that we're starting to recover from some of COVID's challenges. In fact, I really wish we could have similar presentations at other venues because there's so much uncertainty on the part of the insurance industry, the plaintiff, the defense bars about what kind of a world we're in right now. And I know I have a ton of questions for you, but I know we're also pressed for time. So I've been asked to comment specifically on issues that maybe, is going on with insurance, is claims people are trying to kind of figure out what's going on as we start to resume the trials. So just to provide a little bit of background, if we can go back to before COVID, if we can even remember what life was like then, for several years before that, the insurance industry has been tracking increasing severity in terms of really high verdicts nationwide that were all driving higher settlements. Well, then COVID hits and pretty much obviously everything shut down last year. And I'm very interested in Judge Anders' data and Judge Rau's experience during that period of court shutdowns, because we haven't seen much movement in terms of settlements last year, certainly not in the highest exposure cases with some of the more aggressive plaintiffs' attorneys. So we've heard talk of things like COVID discounts, but my colleagues and I really haven't seen that. So now with courts reopening, there's a lot of, again, uncertainty, and not just, again, in the insurance industry. I know it's also by the plaintiffs' attorneys and defense bar too. And, regarding how to best handle cases going forward and what impact there's going to be on verdicts and settlements anyway. So in the context of what I do, which is focused primarily on med mal, some of the issues the insurance industry is considering is, will jurors be more or less sympathetic or favorable to healthcare providers or other defendants? I'm sure we've all heard about this whole halo effect. But of course, does it actually exist? And if it does it only extend to doctors, nurses, the actual individual practitioners, or will it also apply to the institutions and hospitals as people perhaps have realized how important it is to have access to care as we've dealt through this COVID epidemic? Alternatively, will jurors be even more sympathetic to patients and plaintiffs and their families and the hardships that they've had to go through during such a difficult year, and especially when there's still so much ongoing anxiety? Then added to that, I mean, COVID wasn't the only thing that we faced last year. You know, we still have the social unrest. And what impact will that, combined with COVID, have on, you know, maybe a lack of faith in institutions, authority? So how are juries actually going to react to those factors as well? And then beyond the social issues, there are also the logistical ones. And, you know, Judge Anders covered some with respect to Philadelphia, Pennsylvania, but and that's eased my mind with respect to some areas. But we also know that that's still a developing story and that things may change as we really do try to kind of move through this docket. And also things vary very much nationwide. And so, for example, in some venues, there has been talk of reducing jury panels from 12 to 8 or even 6 jurors. And that is something with my personal experience has not really been particularly helpful from a med mal context. Some have talked about exempting jurors above a certain age. And again, Judge Anders, I was very interested, you know, when you mentioned that jurors can postpone service, you know, for I think it was 6 months, if there was a concern about their potential exposure to COVID. You know, I'm not sure exactly how that is going to sway the demographics. And again, that's something we're looking at in all of our venues. Are the type of jurors who might want to defer service more likely to be older jurors or more conservative jurors who might favor the defense? Or are they going to be anxious jurors who might be more plaintiff oriented? So again, what impact will that have as we start to resume trials? Will there be a date certain for trial? I mean, a lot of our venues right now, we have had a lot of erratic activity. We had a trial in California last month that as late as Friday afternoon. We didn't know if we were going to start on Monday morning. It looks like perhaps in Philadelphia, you're a little bit more organized than that, maybe, but we've had in some venues too, thoughts of parallel trial tracks for civil and criminal dockets, so that if a criminal case doesn't go forward, the civil case would go forward. Well, of course, I mean, this makes it a logistical nightmare if you're trying to actually plan your trial, trying to schedule witnesses. You know, in the med mal context, actually in any context, some fact witnesses may no longer be living in the state. So trying to get them may be more complicated because, you know, they may not want to fly, they may not want to travel while there's still active infections going from one venue to another. Will your fact and expert witnesses be as effective if they don't testify in person? You know, in the past, there's always been this preference towards live testimony. But, you know, over the last year, everyone's kind of used to seeing everyone in these little Zoom windows. So does it even matter anymore whether they're live or they're not? Will it actually have an impact? On the plaintiff side, we often have plaintiffs who've suffered obvious physical injuries who come into the courtroom. My side, I think it's to unduly sway the jury, but I know our plaintiff attorney on the panel, his head is probably popping off right now when I say that. But our plaintiffs who often have significant health issues going to want to come into the courtroom for weeks at a time, and what impact will that have on their cases? Will it even be more preferable to have your witnesses testify remotely because, you know, if they're recorded, they won't have to be masked, and so they won't look like they're about to rob a bank? Maybe that will affect. You know, again, Judge Anders gave us some really interesting information about, you know, do masks actually impact juries' perceptions of honesty and issues like that? And you know, it's really curious. You know, how are people going to react when everyone in front of you is masked? Will we lose some of that? You know, will we miss a grimace or a nuance in a facial expression that in the past, at least, we thought told us something? You know, one issue right now too, especially because I am in Illinois, and so it's become a real issue for us, is what happens with delay damages and prejudgment interest. You know, certainly the delays over the last year and ongoing are no one's fault. I mean, courts were closed, and even now there are limitations. So will there be a hiatus in calculating the damages? I mean, Judge Anders, I would love you to comment on that. In my home state in Illinois, for example, the legislature just passed some prejudgment interest legislation, which of course comes at a weird time because in my state, we don't even know when courts are going to open really or how, but we know that interest is going to start accruing starting July 1. So, these are some of the factors that we're trying to consider as we move forward and we try to make decisions about how to proceed, settlement versus trial. We know it's going to be a bumpy ride. I know that we're very pressed for time, and I know that there are a lot of questions out here. Again, with maybe once we get to the section when the Dans finish up their presentation, I would be really curious too with Judge Anderson, Judge Rau saying, we know that there's going to be an encouragement with respect to settlement, but how are we actually going to do that, especially in, say, the highest exposure cases, which are often the ones that I'm involved in, and when we have some of the more aggressive attorneys. And again, I'm not really implying that just happens in Philadelphia, it happens nationwide, but we know with those cases, sometimes you do get to the eve of trial or even in trial before you're even able to move anything. So that's just something I will put out there just because I never had access to the judges. So.
Thanks, Anna. I mean, that's very, I think uncertainty is a big component of the discussion. And one thing you might think about as we segue into the two Dans is I'm interested, and this could be the subject of an entire separate program, but juror attitudes and whether, do you have a reaction to jurors who absolutely want to serve, as Judge Anders pointed out, that you're not really getting, when you have a panel of 35 or 40, you're getting into the 20s because people aren't being selectively weeded out because they may have issues with regard to their service. They want to be there serving. Is that the juror that the insurance companies want on the panel, or jurors who want to serve? I pause on that myself, but I don't know if you have a comment on that before we turn it over to the two Dans.
Yeah, I mean, that's something that we're watching very closely and we will continue to watch. When you read things online, just that's published, you get both sides, right? There are pros and cons to each. We're not, I think, really going to know until we actually start going through some of the cases and start pushing them through trial.
Right, and the data appears to be, I guess, pretty similar in terms of outcomes as pre-pandemic. Well, with that, I'm going to turn to Dan Furhat and Dan Jack. Dan Furhat is a partner, and I'm proud to call him a partner, a fellow partner of mine at White & Williams. But importantly, for purposes of this discussion, he's the current sitting president of the Philadelphia Association of Defense Counsel, or PADC. Dan Jack is a founding member of the law firm of Eisenberg, Rothweiler, Winkler, Eisenberg, and Jack. And for today's purposes is here as the president of the Philadelphia Trial Lawyers Association. I guess I would tee it up for both of you. Of course, feel free to, I know you've have some thoughts about how you're going to present today, but I'm wondering what the impact for you has been personally in terms of your practice, as well as for your clients on with regard to the reopening of the courts in Philadelphia County. Dan?
Yeah, thanks, Andy. I appreciate that. So in my practice is substantially in the medical malpractice space, and my counterpart, Dan Jack, I know yours as well. And I just wanted to touch on the concept that some of our other presenters have brought up, is, the COVID discount. And I've collaborated with my clients, and many of them have consciously chose to keep their cases moving along through the litigation process, notwithstanding the pandemic. In other words, they did not decide to stall their cases simply because the courts were not scheduling trials. And, I think that people attending today's program would be interested, Dan, in what your experience has been as a plaintiff's attorney who handles catastrophic loss cases in terms of resolving cases during the pandemic. And I know Anna Watson had mentioned, there's some erratic activity in other states where there's not firm trial dates. In Philadelphia County, we now have firm trial dates. Have you found, Dan, that you really needed a firm trial date in order to get cases resolved or in a position to settle?
So Dan, before you answer that, Taja has to jump in with the CLE polling question.
Thank you, Andy. I'm going to now launch the second CLE polling question. Please respond to the poll as you see it appear on your screen. There is no right or wrong answer. If you're unable to respond, please send your answer via the chat box.
Okay, well, first off, thanks for having me on. It's been great working with Dan over this past year, Dan Forhat, and with Judge Anders and the entire court to help them put together protocols for moving litigation forward and for getting juries back into the courtroom, which is very exciting. And we are grateful for the great effort on behalf of everybody in getting that done. To answer your question, Dan, it kind of depends. I mean, I think that, and you're right, I handle complex cases just like you do on behalf of the plaintiff. I can give you my personal experience. This past year, before the courts reopened, I had no problem reaching out in those cases that were fully ready for trial. Before I would reach out to the defense side and see if there was interest in resolution, of course, I would have a discussion with my client about the environment, about potential COVID discount, and what I thought about that. And uniformly, and I think I can speak for my colleagues on this side of the bar, I don't believe in a COVID discount. So unless my clients strongly felt otherwise, my recommendation to them would be to give me permission to reach out when the case was ready to be tried, essentially when all the reports were exchanged and a demand was made, and see if they'd be willing to mediate the case while we're waiting for the courts to reopen. I felt as if it would be absolutely appropriate to do that. There was no sign of weakness in doing so. And I made it clear to my opposing counsel that I did not believe there should be a COVID discount, and that if they weren't willing to mediate in good faith, then we're not going to mediate. And I made my demand and went into mediation several times, and I have several scheduled in a couple weeks. Eyes wide open, understanding that if it works, it works. If it doesn't, it doesn't. I'm mediating cases as if I have a trial date coming up. With the courts resuming trials, I think it's made it a little bit easier because, as we say on my side of the fence, trials move files. Trials move files, and it's just made it a little bit easier to get things scheduled in terms of mediation. But I would never, even if there's a year delay in getting a case into the courtroom, I would never pursue talks about resolution unless the case was teed up and ready to go, because I just don't think that it's appropriate to do so, and that you're going to get to the right number in taking that tax. So it's worked for the most part. I think that most of the defense counsel is everybody's ready to go, and the adjusters that we've dealt with have all been pretty good and upfront about where we are, and things have moved not as well as I'd like them to move, but they've moved along.
Yeah,
go ahead.
Yeah, no, and we've talked a lot about, mediation, and I myself have also participated in online mediations during the pandemic, and I agree with Judge Rau. I think they can be particularly impactful. I do think it bears, just talking for a couple of minutes about some other possible ways to resolve a case, including a binding high-low arbitration. I found, Dan, during the pandemic, that it seems like both sides or parties are more willing to resolve their cases by way of a binding high-low arbitration. And what I mean by that is both the plaintiff and the defendant would agree on several different terms, including who the arbitrator would be, either a retired judge or an attorney experienced in that particular area of the law, and what the monetary parameters would be from a damages perspective, meaning a ceiling and a floor. So if you have an agreement where the parties agree to a $5 million high and a $1 million low, the plaintiff's guaranteeing yourself a recovery of $1 million, even if there's a defense verdict, and the defendant is capping its exposure at $5 million, even if there's an award of $20 or $25 million. Now, not every case lends itself to a binding high-low arbitration format. And on the defense side, in the medical malpractice arena, I would say that my experience has been that there are a certain class of cases that end up in this kind of an alternative forum. And a good example would be those cases where liability is questionable, whether the hospital or healthcare provider, or where the hospital or healthcare provider believes that there's a good chance of a defense verdict. And also if the damages are limited in the case, and that would be one class of case, in my experience, where clients would be willing, both sides would be willing to resolve the case by way of a binding high-low arbitration.
I agree with everything you said, Dan. The other added benefit to doing a binding high-low arbitration is there's no appeal. So you get paid usually within 30 days of the arbitration award. It gets addressed and you're moving on, which is an incentive for the plaintiff to do that. Another reason why you may want to consider doing a binding high-low, beyond what you mentioned, is obviously there are certain jurisdictions in Pennsylvania, other counties and things of that nature, which are notoriously conservative, where your chances of getting a plaintiff's verdict, and then I'm not speaking out of turn, everybody knows this, your chances are different than in other jurisdictions, other venues. So you may want to consider it in those contexts. I think in the complex cases, I tend to not do that. I don't think I have any cases with really difficult where I feel that, I always feel as if our liability is very strong. The damages are different depending upon the case. It happens every now and then to do that, but I tend to shy away from it. But other people do, and it works out well for both sides. If you can agree to that. Again, I think the key to either deciding to go to high-low or getting a case settled in this environment that we're in right now is that everybody has to be ready on both sides of the fence. What Judge Anders and Judge Rau, I'm speaking for them, but I think I can because I've heard them over and over again, and I'm a student of them. Things only get done when everybody's ready to get it done on both sides. And the idea of setting up these little the settlement conferences and these meaningful events, as Judge Anders would say, meaningful events in a court as you get closer and closer to trial. The idea is to get both sides to get ready to go, because unless both sides are ready to go, it's not going to work. So from my side, I've been doing this long enough, and I have a good relationships with many of the defense lawyers that I work with. I say to them, are we ready to go? What do you need to do to get ready to go? And how long is it going to take? And what do you need from me? And once everybody's ready to go, then you have a good shot at getting it done. So I'm grateful for the courts in moving things along, because it's helped us reach those types of points to get cases settled.
So Taja, do we need a third polling question? And if we do, let's do that now.
Yes, I'll launch the third CLE polling question at this time. You should see the question appear on your screen. Again, this is purely for attendance. There is no right or wrong answer. Please send me if you're unable to respond via the poll, please send me your response in the chat box. Thank you.
Okay. Dan, you want to wrap this up with maybe one more area? Either Dan, I'm curious as to what you think the challenges are in the courtroom that you've seen Judge Anders, show by photographs.
Go ahead. I was going to just give 30 seconds about that, and then I'd like to see what Dan had to say about it. From a plaintiff's perspective, and we have a couple cases that are coming up. We haven't tried one yet in my office in the new courtrooms, reconfigured courtrooms, but we have them coming up. But we've had lots of discussions about it. We've talked to lots of people. One, we're always prepared to go in and try cases. I think preparation under these circumstances is even that much more important. Two, we talk about rules. Okay, so the courtroom is always about rules. Who's following the rules? Who's breaking the rules? Who should be responsible? Now we have rules as lawyers on how to conduct ourselves. You're going to have to pretty much sit in your seat, and you're not. And I listened very carefully to what Judge Anders says. That he's told us that jurors have responded to him that they get nervous when the lawyers are lurking about. So as a lawyer on both sides, I think we need to be very cognizant of the rules. We've asked these people to come in, sit as a jury and obey the rules. And if we violate the rules, even inadvertently, they could hold it against us and hold it against our clients. So we have to be very, very careful, wash our hands in front of it, do everything we need to do. The other thing I would do is I always try and strike some type of comfort level with the jury. It's going to be harder to do that under these circumstances, but you still got to do it. So be self-effacing, be apologetic, be yourself, and try and reach that comfort level. The last thing I would mention under these circumstances, and I always try and do it in regular trials under regular circumstances, is to provide some type of entertainment level for the jury. You know, more animations, more photographs, more diagrams. I mean, things to just break up the day. We're going to be forced to sit at a table and ask questions and get answers for 6 hours or so each day. You have to remember who you're talking to, who you're trying your case to. They're not used to this. It's going to be uncomfortable. If you can break it up by having more demonstratives, interesting things to do in a courtroom, both sides should do it, in my opinion.
Yeah, all great comments, Dan. All great comments.
Yeah, I mean, a lot of this is unknown, and I was listening with great interest to what Anna had to say about, from her perspective in the insurance industry, and one of the comments I heard you make, Anna, was that, you know, robbing a bank, you know, the plaintiff might look like they're getting ready to rob a bank. The reality is, you know, we're all going to look like that. So Andy and I are going to be getting ready to try a complex medical malpractice case in a few weeks. And, you know, when we give opening statements, we're going to look like we're robbing a bank as well, I guess. So I think we're all in a level playing field in that regard. For me personally, I think that being confined to my seat, I'm going to find that to be somewhat of a challenge. I would prefer to be standing up and walking around, but I also know that the court has been very good with explaining to the jury why the attorneys have to do what they do. We're not being disrespectful. We're not trying to be, it's not that we don't want to be walking around. We're doing it to keep everybody safe and to respect the process.
You know, one of the issues that Anna raised that I wanted to give a comment on is, you know, she was concerned about what are our juries going to look like in the professional medical negligence area. And one of the things that this online world has brought us is that you can actually do mock trials more economically than you used to. You can get a larger number of jurors who are doing things online, or you can do a summary trial to kind of figure out case value more quickly and more economically than usual. So it's one way to kind of check out whether that halo effect is going to affect jury verdicts or not.
Yeah,
Judge Anders, I'll give you the final word.
I'll jump in just to address one point about peremptory strikes and the size of the juries. If you demand 12, you're going to get 12. And it's 12 plus 2, so it's 14. There are some jurisdictions, well, the Supreme Court has allowed us as a county to request that we reduce the number of peremptory strikes if we need to. We have not taken that route. Other counties have. We think that your ability to exercise peremptory strikes is very important to your trial strategy and ensuring that you get a juror that you want. And so we have not sought that permission from the Supreme Court to reduce your strikes. But I will tell you that on an average, let's say 2-week-long med mal case, we really need you to pick your jury within the 40 jurors that we give you. We can't spend two panels on one jury. Now, of course, if it's a longer trial and you need 2 days to pick a jury, we will give you 2 days, but those things should be addressed up front.
Okay, so thank you everyone for participating. Appreciate the two judges' time, Anna, Dan, and Dan. And until next time, everybody stay safe, and Your Honor, thank you for all your efforts in Philadelphia County.
Thank you, everyone.
Thank you, everyone.
See ya.